Greetings to all fellow concerned Americans. I am Thomas J. Miller, and I will be speaking about the other way to amend the U.S. Constitution via Article 5, Convention of States. What's old is new again. There are two methods to amend the U.S. Constitution via Article 5. Only one has been used. The other via Interstate Convention, although not used to amend the Constitution, was quite familiar to the founders. Our current understanding of the constitutional amendment process, even via the convention, even among those working in constitutional law, has faded in the 20th century. However, in the 21st century, this historical knowledge is returning. Yet we have myths and fears not based on a historical record nor facts. The greatest myths, in my view, are that the convention process has little historical precedent and there's no solid legal foundation to amend the Constitution in this manner. Here is the relevant section of Article 5 of the U.S. Constitution. The Congress, whenever two-thirds of both houses shall deem it necessary, shall propose amendments to this Constitution, or on the application of the legislatures of two-thirds of the several states, which in either case shall be valid to all intents and purposes as part of this Constitution, when ratified by the legislatures of three-fourths of the several states, or by convention in three-fourths thereof. Four salient points are set forth in Article 5. 1. Two distinct methods to amend are presented, one by proposal and one by ratification. Both have been employed. 2. When two-thirds of the states, 34, make application, the Congress for a convention, this triggers the call automatically. 3. Congress shall, i.e. must, call a convention. 4. The powers granted to the convention are to propose amendments. If amendment survives the convention to be voted upon by a majority, then three-fourths, 38 of the several states through their legislative bodies, one vote each, must adopt the amendment for it to become an amendment to the U.S. Constitution. This is an intentionally extremely high standard to meet. A convention for proposing amendments is usually called a convention of the states, which is neither rare nor likely to go off the rails as suggested by modern era critics. There have been more than 40 conventions of this type in our history. The first one was called in Albany, New York in 1677, and the latest in Phoenix, Arizona in 2017. To propose a balanced budget amendment for that limited purpose. I wonder how many people are aware that the 21st Amendment to the U.S. Constitution was ratified by state convention, by the legislatures and not by amendment. It was done by a convention. In summary, a convention of the states is only to propose amendments that can only then become part of the Constitution if a very large consensus of the legislatures agree. And in fact, the state of Louisiana fairly recently passed an application, as have 13 other states, including Florida. And the Louisiana application sets forth that their commissioners not all be legislators, so some of them have to be just citizens or, non-legislators. And after the convention is held, the Convention of the States, the commissioners will report back to their respective state legislatures to consider the proposed amendments. The chance of any substantive revision or repeal of the existing Constitution and amendments is very slim, with the virtually nil, with the scope of the subject matter clearly outlined in the application, which is the same subject matter for every state, and otherwise they wouldn't have a convention. And our current reality is that the Constitution, in my view, is effectively judicially rewritten and means whatever a majority of the U.S. Supreme Court rules that it means. Whether one agrees with the Supreme Court holding or not, this should greatly concern all of us. I submit this is not objective rule of law, but rather subjective rule by 9 unelected people who, in my not-so-humble opinion, over and over place policy considerations deferring to the executive branch above constitutional jurisprudence. This is the very antithesis of co-equal branches of government that were set out by the founders to balance each other.